It's at a little bit of a different time, but 2 o'clock this afternoon, but good to have everyone. I'm sure y'all are familiar with the rules, which includes watch out for your timing. When it turns red, you're done, but if we're still asking questions, you can't run away. So with that, we'll go ahead and get started on this one case. Case number 24-10432, Palo Pinto County versus Shane Long et al. And we will begin with Tony McDonald for Palo Pinto.
Good afternoon, and may it please the court.
I'm sorry, I should have said Palo Pinto County Conservatives. I knew it wasn't the county itself. Go ahead.
Yes, Tony McDonald on behalf of the Palo Pinto County Conservatives and Joanna Miller and her other group. I want to give you the rubric for this afternoon's presentation. It's 1, 2, 3. We have one unconstitutional order by the county. We've got two mistakes in reasoning by the county that informed their decision making on that order. First, the county thinks it can treat open lawns and open lots around a polling location the same as it can treat a room full of voting equipment. They say that's a distinction without a difference. The second mistake the county makes is to think that it's okay to be openly, admittedly hostile to electioneering as a type of speech. And three, my third point here, we have three solutions for this court, three solutions we think this court should adopt to avoid this being repeated by other local governments. First, the court should find that strict scrutiny applies. Second, this court should clarify that there are three types of forums, not four. And third, this court should go further than the emergency panel and should enjoin the entire order.
Yes, I was going to ask you about that because, well, I'm guessing you know, I was on that panel. Why wasn't keeping those safe, right? Because those really were safety rulings or decisions, right?
So I disagree because of the exact nature of the order, and I think it's important for this court to speak with clarity about what's allowed and what's not allowed. And I think it'll be a powerful thing to say that these elements, which again at first blush seem completely reasonable, don't drive T-posts into our lawn, right, is an incredibly reasonable rule to make. But it's not a reasonable rule to make when you say, don't drive T-posts into my lawn in order to hoist a political sign. There's no rule that says I can't put a T-post in the lawn to put up a banner. We actually had a discussion at the temporary injunction hearing, a banner that says I install Christmas lights, right? There's no rule against that. Similarly, there's a provision in the rules that says don't obstruct the vision of drivers. Why is it that we can't put up a political sign that obstructs the vision of drivers, but there's no rule that says, you know, if Tony wants to get out there and say the Gros Michel is the true banana, the Cavendish is a fraud, or go Rangers, or honk for Jesus, that those signs are not prohibited by this order. And so that is the fundamental mistake.
But even at the highest level, if it is securing safety, why wouldn't that be okay? Even if the county should do more than they did, why isn't that good what they did on those points? Like I said, maybe they should have done more, but even at the highest level of review, it would seem like something that's unsafe, that's going to hurt someone, is something they should ban.
Well, I think it's part of the analysis that this court applies and part of the review. As you look at it, you say, what's the compelling interest here? Well, there's compelling interest in safety. I don't think anyone disputes that. But the question is about the narrow tailoring. So here we have in what is a traditional and or designated forum, a content-based policy. What Reed tells us is that's presumptively unconstitutional. And then the county then has the burden to show what's the compelling interest, which I think you can infer certain compelling interest in don't have distracted drivers. But then you get to the next step, you say, what about narrow tailoring? You don't have narrow tailoring because, again, what we have here is something that's targeting political speech and political speech alone.
Yeah, but you're saying it's too narrow, that they should target all speech that does this, but maybe they've never had an issue with any other kind of speech, and so that's why they focused on this. But why isn't it narrow? And why isn't it proper to ban, something that would hurt someone physically, not just, oh, I don't like your politics?
So this is the concern that was raised by the court in Reed. They say even when there's innocent motives for content-based laws, it opens up avenues for abuse. So even when there isn't a desire to do that, and you really see it here, potentially you do have hostility to electioneering as a type of speech, and that was admitted on the stand by Judge Long, and we can talk about that. But beyond that, obviously they're going in and saying, we're writing an order here dealing with electioneering. That's why this court needs to say to local governments out there, no, when you're going to regulate speech, it's important that you not start with a content-based regulation. If you're going to do something that is generally applicable to everyone, that's going to be subject to a lower standard of review. When you single out a type of speech, that means that you're really, that's a tough road to hoe. So,
saying if they change 2B to no one may post signs using posts that may damage subterranean water and electrical lines, then that would be okay if they took the word political out of it.
Taking away the admitted hostility to electioneering that we have in the record here, then I would say, kind of as a first instance, you're looking at a regulation, I would think so. I mean, I would think if you said no one should post a sign on our county lawn using T-posts, I don't think that there's a First Amendment case there, and I certainly wouldn't be bringing one. But whenever you single out the political signs, you're treating political content different.
Even when it is dangerous, physically dangerous, not just politically, but physically dangerous, you still think you cannot set any such standard?
To be clear, it's that you can't, it doesn't satisfy the narrow tailoring that's required because it's content-based. So were you to have a regulation that says no T-posts on our lawn, that's not singling out speech on the basis of its content. There are many ways to approach whatever necessary policy making needs to be made that doesn't single out content. And that's what the Supreme Court has told us, is that the singling out of content is the danger that this court has to protect against. And so that's why we're saying to this court, send a clear message by striking down the entire order to say, hey, look, even whenever you're dealing with something like distracted drivers, you need to go about doing that in the right way. You can't single out certain types of content to get there. There's no good reason to do that. And certainly the county hasn't met its burden to show why it would single out that type of content. Turning to the treatment of the lawns, Supreme Court in Burson, 7 of the 8 justices applied strict scrutiny. I think it's clear there is no precedent that binds this court to apply some lower standard. That's the error that the trial court made, to say that we're going to treat, because of Osterwich, we're going to treat a ruling that deals with the inside of a polling place, that 100-foot periphery buffer zone, we're going to treat that the same as these open areas. And really what we would say is this court should speak with clarity about forums. That's been one of the major points of confusion here. The Supreme Court in Mansky clarified that what used to be called a limit, they basically struck the term limited public forum from their lexicon. And I think this court should do the same. And the reason is that it causes confusion. It leads to that same circular reasoning that was identified in OSU Students Alliance v. Ray, where governments think, okay, it's a limited forum, that means that the limits on the forum can then justify the forum. And you end up with, it's just, there is no rule in place. What the Supreme Court has made clear is what that really is a non-public forum. So we're talking about a non-public forum. What the Ninth Circuit has actually used a good piece of terminology to say a non-public forum opened for a limited purpose, in lieu of using the phrase limited public forum. I think this court speaking with clarity on that subject to say we have traditional forums, we have designated forums, and then we have non-public forums that are open for a limited purpose. That helps in understanding this case. And so when you look at this case, you say, is the parking lot where we have people outside congregating to electioneer and talk to their neighbors, is this a non-public forum? Well, of course not. Of course not. It would be somewhat draconian for the government to stand out there and say, well, we've opened this for electioneering, but darn it, you have to stay on message. You can talk to people about electioneering, but if your conversation strays to the weather, if your conversation strays to baseball, we're going to step in like you would in a governmental meeting or something. Or if I stood up here and started, spouting off something that didn't have to do with the case. That's a non-public forum. This is an open field. The Third Circuit also has commented on, and I like one of the items they've used is to look at whether the place is open to all comers. So for instance, if everyone is allowed in, that then is indicative that it is a traditional forum. And that's what we have here. Everyone is allowed into this lot to electioneer. And there's nothing that, there's no real gatekeeper there.
What does electioneer mean? I mean, there's no definition of political, there's no definition of electioneering. How does that cut? How does that affect our analysis?
Well, I think it tilts in favor of protecting speech because it is unclear. And in fact, when we had Judge Long on the stand, I asked him, can you define electioneering? And of course he says, no, I'm not an attorney, I can't define electioneering. But then when we went through the hypotheticals, he made clear that for a person to be in the designated electioneering area in the side lot, and then let's say you're in the middle lot, and you say to me, hey Tony, can you tell me more about that candidate that you're talking about? Even if I went over to hand you a nonpartisan voter guide, something that wouldn't be regulated as, campaign finance electioneering speech, even if I had nonpartisan materials, entering that space to hand that material to you would be a violation of this order. So I think it really does suffer from a lack of definition, and it's an unworkable lack of definition. As we were preparing for this, I started looking at McCullen v. Coakley, the Massachusetts abortion clinic buffer zone case. And one of the things that the court took particular issue with there, the Supreme Court took issue with, was that Massachusetts said, oh, well, your speech is not chilled. You can be 35 feet over here and still say the same thing. And what the court said was, it's not the same thing for you to be shouting at somebody from 35 feet away. We want to be able to actually walk up and talk to people in a friendly way. And that's exactly the testimony that we had from Joey Miller in this case. Hey, I'm not trying to accost anybody. I want to walk up in a friendly way to people and say, hey, do you know who you're voting for? Can I give you some materials? And these orders clearly stop that and create a cloud on what is allowed and what's not allowed out here in these open spaces on the lawn. Briefly to talk about the entire order, one section that was not addressed by the emergency panel, there's a line here in 3C, no one shall post or place political signs in public easements or rights of way. And that was
one that we did not find.
Correct. Again, I would say
an injunction.
I would say it should be addressed because we're talking about political signs. It's singling out content. Why content here? But beyond that, I think, you look at it, you say, well, what impact does this even have? You know, under the surplusage canon, this is assumed to have some kind of meaning. And I think what this actually makes clear, or at least makes clear enough to create a chill on speech, is that this is limiting speech on that sidewalk that rings the entire annex grounds.
So you think 3C is the same as 2B and 2D in your mind?
Well, it's
Or the three that we didn't?
well, it's different in the sense that there's nothing implicit in it that would justify it. Because to me, I think that reaches to the sidewalks that ring the annex lawn. I see I'm running out of time, so happy to answer questions or happy to come back up for rebuttal.
Okay.
Thank you.
Thank you. All right. Grant Blaies represents the Palo Pinto County Commissioners. I'm sorry if I got your last name wrong.
It's perfect, Your Honor.
Okay.
Blaies is correct. May it please the court, counsel. Before we start getting into the specifics of the regulation in question, what has to be answered is, what is the standard to be applied in evaluating these regulations? And I think the Supreme Court has morphed towards Justice Scalia's concurrence in Burson in the Mansky case, and then as followed by this court in the Osterwich case. You've got to kind of look at how that jurisprudence is developed before you even start talking about these regulations, because in those cases, the regulations at issue were complete bans on electioneering, not what we're trying to do, and that is accommodate some level of electioneering within the polling area. Those cases addressed absolute bans on electioneering, all of which were upheld to be constitutional. And the reason is you have two competing constitutional issues at stake here. You've got the First Amendment right to free speech, but you also have the right to vote. And you have the right to vote free from voter intimidation.
Then why didn't what we, the motions panel, did, why didn't that pick it right? Because things that had to do with safety, we went your way. Things that didn't, we went their way. Why isn't that answering exactly what you just said?
Because it's really not, it's not really a safety issue. And I will tell you, these are not content neutral regulations, but by definition, they're not content neutral regulations. All electioneering regulations are not content neutral because they address the specific circumstances of voting, okay? And this is where I think it's important that the court kind of understand the evolution of what we're talking about. In the Burson case, there was a complete ban on electioneering within 100 feet, and the court were struggling. Well, is this a public forum? Is it not a public forum? Do we apply strict scrutiny? Do we not apply strict scrutiny? And what they did is essentially gave lip service to strict scrutiny, but then said, well, it's not really strict scrutiny because you have two competing constitutional interests. So really, these are not presumptively unconstitutional bans. What we're going to say is so long as it doesn't significantly impinge on the constitutional right, then they're going to be allowed and proper. Justice Scalia said, wait a second, y'all are talking about public, non-public forums. History and tradition tell us that the polling place and the areas around the polling place have not been open to the public. They are considered non-public forums in order to achieve the compelling governmental interest of keeping people away from being harassed.
Texas does that 100 feet exactly for that purpose.
Yes, Your Honor, and in that regard, I believe it was Burson said, the 100 feet is a matter of constitutional degree and not kind. They found the 100-foot ban to be perfectly constitutional, but they said anything more or anything less, again, that's not an in-kind constitutional analysis. That's a degree.
To address what you're concerned about, just making sure people can get in and la 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 and all of that. But the reason why the politicians want to be there is because that's a way to talk to people they know are going to vote. You don't always know who's going to vote. If you're sitting around in Dallas, there's a lot of people there, but they aren't all going to vote. So who do you want to talk to? Oh, my heck, they're about to vote. Okay. So the 100 feet is to try to keep things calm. And I get that, but that's not, y'all are going farther.
Well, and I think Justice Roberts in Mansky, as well as this court in Ersterwijk, said the time for persuading is done. Now it's a time for choosing. We are not trying to restrict anybody's ability to get their political message out, but on election day, when you're walking to the polls, there is a compelling governmental interest to say, look, you're done trying to get your message out. These people should be able to access that polling place without the fear of intimidation.
So do you think you could just ban electioneering altogether?
I do not think you can ban, I don't think you...
I mean, on that theory you could, right?
Well...
If the theory is like the time for talking is over.
I think that this is where I think Shermer's instructive. Because in Shermer, this court, right after Burson, held an absolute ban on politicking within a 600 feet radius to be constitutional. Now, obviously, we can take that ad absurdum and say the entire city is now you can no longer electioneer in the entire city. But at that point, you're no longer facing a forum analysis. Because at that point now, that's a law of general application that's going to be impacting other areas other than the forum, which the forum in this particular case is an annex. It's a single building, a single property. I do believe that if the county would have enacted a total ban on electioneering outside of the curtilage of that building, there would probably we have a conversation about its constitutionality. But that's not what we have here.
Can I take you back to Judge Willett's question, because I'm hung up on the exact thing that he put his finger on, which is because we're banning about cases where you say, oh, total ban, 600 feet, 100 feet, Mansky, Ostrich. One of the things that is very apparent to me in each of these cases is that the content of the regulated speech differs across these cases. So, for example, in Ostrich, when we're talking about the Texas statute has a I mean, you could say it's better or worse or more specific or less specific, but it's definitely different than what the Palo Pinto County did in this case, because it has for or against people on the ballot. Like, it gives some sense of like what the regulated speech is that yours doesn't. So Judge Willett asked you, what is electioneering? What is political? I have no idea what those words mean. And I'm particularly troubled because I'm reading the transcript from the injunction hearing, and it sounds like there's no really good definition given in the record either.
Well, actually, electioneering is defined in the statute under section 61.003. Mm-hmm. It's the posting, use, or distribution of political signs or literature. That's the definition of electioneering. Now,
but it's not talking.
Granted, that's we can have a conversation with the Texas legislature about, but that is defined, and that's why that language was used in these regulations. So we're trying to comply with the requirements of section 61.03 using the terms that are defined in that statute. So relative to that, again, what we're dealing with now, though, is, and I want to say the court in Shermer, Ersterwijk, and Burson said, perfect clarity and precise guidance have never been required, even of regulations that restrict expressive activity. Well, what do they mean by that? Well, to follow up, I guess, in this court's opinion in Ersterwijk, when you're dealing with a facial invalidity, the finding these sections facially unconstitutional is daunting and requires us to find that a substantial number of its applications are unconstitutional, judged in its relations to the statute's plainly legitimate sweep. Well, what does that mean? Well, what that means is, unless it's difficult to find a statute's facially unconstitutional, but there may be an as-applied challenge, but this is not an as-applied challenge. And if they want to have a conversation about, was this poster violative or not violative? Well, if in fact they are harmed by that, by an irrational, arbitrary decision of the electioneering people, then they may have an as-applied constitutional challenge. But right now, we're not dealing with an as-applied constitutional.
The Supreme Court's also been pretty clear that when you pose criminal penalties on speech, which is what the county decided to do here, right, Class C misdemeanor, that you have a different obligation to be clear in the way that you're telling people. They don't have to run afoul of it, face the criminal fine, and then beg for forgiveness later. They're supposed to have some clarity about where the lines are.
And I would respond, I agree with you, Your Honor, but I would respond as follows. First of all, if you look at the actual electioneering regulations, they follow the state statutes, and there are, in some sections, civil fines, but there are also criminal fines. So violating an electioneering provision of the Texas Election Code is a potentially criminal matter. So did they rubber stamp that in there? Correct. But if you look at the posting restrictions, the very last one, it's subsection 2G, and it says any political sign if you violate these regulations, we're going to remove the sign and we're going to put it in storage, and you can come get it or we're going to destroy it. So again, if as applied somebody gets arrested because they want to engage in activity that they think is constitutional, bring the as applied challenge. But on its face, it's a fairly reasonable remedy for potential violation. But again, what I would say is these electioneering regulations are meant to allow over 75% of the property for electioneering. Only 25% of the property is an area where it's designated no electioneering. That is substantially more, I don't want to say constitutionally beneficial, because if that's a thing, but then completely banning electioneering on the property, which was held to be constitutional in Shermer. If we would have said within 600 feet of the polling location, all electioneering is banned, that would pass constitutional muster under this circuit's authority. What you have here is a less restrictive regulation, which is allowing for electioneering on the property. It's just within the confines of the limits that have been placed.
Counsel, can I try to get at the concern this way? It depends a little bit on how you count, but the motions panel enjoined all but, by my count, 4 provisions of these regulations. 3 of them, 2B, 2D, and 3C, don't say anything about electioneering. They just say no political signs, right? So 2A says no political signs in the ground. That's the one about subterranean water, et cetera. 2D says you can't post political signs that obstruct a vision, and then 3C says no political signs that obstruct a right-of-way. So 3 of the non-enjoined, and by when I'm saying enjoined here, I'm referring to the stay pending appeal or injunction pending appeal from the state panel, has nothing to do whatsoever with electioneering, and it just says political. So my question to you is, what does the word political mean? What's a political sign?
I think it's a very good question, and again, if you apply common sense, what it is the issues that are being addressed and decided within the confines of that election period.
What if it's a political statement that's not on the ballot?
Well, if it's a political statement that's not on the ballot, under these regulations, you can put them up so long as you're limited to 6 and they're not too big. I find that I doubt that would happen.
I mean, there's nothing about ballot anywhere in these regulations. There's nothing about says for or against or ballot. So how would anyone know that?
Well, again, I go back, and I hate to do this, but flip it. At least we're having the conversation of what is allowed. These regulations allow it. The regulations in Shermer said, no, you can't. And this court said, that's the Constitution. You can do that. So I guess when we talk about that, I do appreciate the question, because you're right. When we're talking about what does political mean, I mean, that can be subject to construction and interpretation. But it's not necessarily unreasonable to have that in a regulation, given that the Texas statute, that's what it says. That's what these regulations say. And I would, again, a common sense analysis of that would be, what are we dealing with during that election period? Because remember, I didn't mean to...
I'm sorry, I just wanted to make sure I understood what you said. I didn't see the Texas statute using the word no political signs. Am I misunderstanding what you said?
They use the word political. Mm-hmm. That's electioneering. Electioneering is distribution, use, and postage of political signs and literature.
Meaning things that are on the ballot on the particular election.
Well, they don't say that in the statute.
I'm sorry.
Again, I would think, excuse me, I would think common sense would apply, and could somebody come out there and want to put a sign up about something that is really not at issue in the election? I guess theoretically that could happen. But I guess I don't think you can throw out the regulation because of that hypothetical. Again, that would be a situation where let them try it and see what we do. That would, again, be an as-applied challenge, I think, than a facial challenge to the regulation. And again...
But I mean, when somebody's being elected to the county commissioner court, for example, almost everything under the sun is something they do. So that's all political. I mean, so you're basically saying everything is political. So maybe if you're running for some very specific thing that only covers X, Y, Z, then maybe ABC isn't political. But a lot of things, I mean, even when you're running for judge, while you're not to be political, you still have to run for judge, and a lot of what you get quite a variety of stuff as a judge in county court, district court, court of appeals in Texas.
That is correct, Your Honor. But again, what we're talking about, and this is where I depart from my counsel, and that is, by definition, electioneering regulations, and by definition, the electioneering provisions, they're not content neutral, because we're not talking about. So the Reed doesn't apply at all, because that's a statute of general application throughout the city. This is a content specific, location specific, time specific limitation dealing with the sole issue of trying to prevent voter intimidation and voter fraud. How do we do that? In that curtilage, in that area, on that property, we're not going to allow people to go do your electioneering door to door, mailers. Get out there, get the vote, get your message out. But you know what? During voting day, you can't hang around within this radius. And when we talk about, again, when we talk about these electioneering regulations, these are allowing for that, whereas there have been complete bans that have withstood constitutional scrutiny.
Okay, let me ask you this. Let's just assume, arguendo, you were in front of the motions panel and we told you we were going to do some and support some and not other. Where would you draw that line? I mean, does it make sense what we did in terms of the 2B and D and 3C? Or is it all or nothing? Period, end of story.
As an advocate, but I understand what you're saying, but here's what I would say. And again, it comes back to, well, what is the analysis? And the analysis is viewpoint neutral and reasonable. It's a reasonableness analysis. And the deference is to be given to the district court in relation to that. All of these regulations, I would say, passed the reasonableness test, and the trial court was within its discretion to deny that injunctive relief, because these would pass constitutional muster. And again, the reason I know that I'm banging a drum here, but the reason that it would pass constitutional muster is because they are allowing for electioneering. Whereas if this regulation said no electioneering whatsoever, basically if they said you can't do any of this, you just can't, no placement of any signs, that would be constitutional under this court's authority. And so when you're talking about what provisions allow for electioneering, that's clearly reasonable, because we're doing something that the Constitution doesn't even proscribe.
Counsel, here's the thing I'm hung up on. I'm sorry,
No, go ahead.
I'm hung up on is, you've read Mansky.
Yes, Your Honor.
So in Mansky, we're talking about speech inside the polling station. This is your best case, right? This has got to be, if there's a place where the state is allowed to regulate and prevent people from electioneering or engaging in political activity, it has to be like in the ballot box, right? So this is like the heartland of what you're saying. And Chief Justice Roberts says, yeah, well, the Minnesota statute uses the word political. It doesn't define the word political, and therefore we can't be confident that the lines the state is drawing are reasonable, and the state loses, right? Are we reading the same case?
We're reading the same case, but we're reading it in different sections, because what I was dealing with in Mansky was, again, the forum analysis. And what Mansky essentially, because at this point, technically under Burson, they were applying strict scrutiny, although not really. What Mansky essentially did is, Robertson, he kept talking about the plurality and Justice Scalia's concurrence, and they talked about, and you're right, they were dealing with just the curtilage, they were dealing just with the location. But they said essentially that it's common sense that a campaign-free zone outside of polls is necessary to secure the advantages of the right to vote, and the state may reasonably take steps to ensure the partisan discord not follow the voter up to the voting booth. So what they essentially said in Mansky is, okay, yes, the inside is clearly a non-public forum. But you know what is also a non-public forum? What Justice Scalia said. and that is the whole area and the curtilage.
I'm
Now,
following you. The thing I'm worried about is that this move that I hear you making this afternoon, which is we could ban it. We could ban it to 600 feet, and we're giving you something, so you should say thank you, not what does political mean, right? I don't mean to put words in your mouth or be cute, but like I understand the argument. it seems inconsistent with what the court did in Mansky, because Minnesota tried the same thing.
here is where, and again, this is a great point. But that's really not, that hasn't been challenged by the other side. That hasn't been part of the briefing. And frankly, a post-hearing briefing, if you would like, I would welcome it. But really, what you're talking about is the age-old question that is probably faced every legislature. It's faced every judge. It's in 61.003, and that is what's political. You make a great point, but at some point, you just got to use the words that everybody's using. And so, we're just using the words that the statute that's been deemed constitutional contains. But you're right. I mean, political is what one thinks it is. Some people live their life, it's all politics. So great question, but I don't think it applies in this particular case. My time is up. I appreciate it.
Okay, thank you. We'll now hear the rebuttal.
I want to return to the three solutions that we proposed at the beginning of this presentation. I think that those solutions will help give clarity to other local governments like Palo Pinto County to understand what they can and can't do and how to approach these questions. First, it's clear that strict scrutiny should apply. The county relies on Scalia's concurrence in Burson, but 7 of the 8 justices there found strict scrutiny applied. They rely on Schirmer, but in Schirmer, this court applied strict scrutiny to Louisiana's regulation. And if you look at Schirmer, you find that it's highly fact-specific. The court goes through and tasks the state with showing why it is this 1980s era regulation dealing with paid poll workers and the specific problem of paid poll workers in the state of Louisiana in that era, why they needed such a broad regulation. And they found that the state succeeded to meet strict scrutiny, but nonetheless strict scrutiny applies. And so this court should be clear that whenever we're talking about regulations beyond the 100-foot buffer zone, strict scrutiny applies. Second, there's clear confusion about forums. What is a traditional forum? What makes a designated forum? Is limited public forum a valid label to use anymore? I would suggest if you look at the polling location itself and the 100-foot buffer zone, we're talking about areas in which loitering is prohibited by the state. You can't just be there. You have to be there to vote. You have to be there for a reason. And so it's very different than the areas beyond that 100-foot zone. We have an area where people generally are not allowed to be unless they have a reason to be there. And we have open fields, open lots around it where people are generally allowed to be, and then the county is trying to put regulations in place. I think this court can speak with clarity to say there's 3 types of forums: traditional, designated, and non-public, maybe non-public open for a limited purpose. I like that terminology. I think it's helpful. And show citizens what it is, what it means to be in those different types of spaces. Is it open to all comers or not?
Win on some and lose on others?
I'm sorry, I don't understand your question.
Well, you keep saying we need to set this out, the traditional, the designated, the non-public. Is it because you would win if we designated this as X, but we would lose if it was Y? I mean, that's what I'm trying to understand. Or would you win regardless of what we called this?
I think we win regardless because of the sloppiness.
Then why should we set it out?
Because of the sloppiness of the regulation. But I would say I think we win because it is either a traditional forum or the state has designated this forum by saying, hey, you can't ban electioneering beyond the 100-foot zone. That is an interesting element here, where the state has designated a zone. And so because of that, then we know if you have a content-based regulation in a traditional forum or a designated forum, that is then presumptively unconstitutional, and then the government has the burden to show why that's narrowly tailored to a compelling interest. If it's a
Non-public, would you still win?
we would still win, but it would be it would be a tougher burden for us because the presumption would go away. The content-based presumption would go away, and we would then be looking at, is this a reasonable regulation? Well, I think it's not a reasonable regulation for all the reasons that we've discussed, but I think that's an error. I mean, clear error from Shermer, from Burson, to say that this is a non-public forum out here in these open lots. I think it's actually, I described it, it's kind of draconian. To be a non-public forum, you almost would have to have somebody out there who's standing over the shoulder saying, well, stay on message, you're electioneering. And the two people are talking and going, why is that guy looking over my shoulder, you know? And you're not allowed to talk about that because you're supposed to be out here to electioneer. That doesn't make any sense. I mean, that's kind of silly. So I think that, and then finally, the final thing, and I only have 20 seconds, I would ask the court to enjoin the entire order. I think it sends a message. It's content-based. That means it's presumptively unconstitutional, and they haven't met their burden. It sends a clear message that we're not going to get in there and, you know, say you can do content-based things if it seems important.
Okay,
Thank you.
This case is now under submission, and we're done for today, and we'll be back tomorrow at 9 o'clock.